with the use of due diligence. So that's sort of a legal term of art. You'll hear it stated differently as you knew or should have known. But when you think about the standard, knew or should have known, what courts are basically saying is that a reasonable business owner in the same or similar circumstances would have discovered that hazard in question. So that's the standard that we're looking at when we look to, things like spilled liquid on the floor and someone tripping and falling, but it's also going to apply in this workplace violence scenario as well. Okay. So the good news for business owners with that sort of general framework in mind is that a crime is generally not something that they will be expected to anticipate and that they will therefore be liable for. Now, there are some exceptions to this rule. If the crime in question was one that the business owner knew or should have foreseen given the type of situation. So there's no uniform standard as to when a business owner either knew or should have known, but courts will generally look at whether or not a business had ever experienced an act of violence previously, if the business had any run-ins with individuals that should have given rise to concerns, and other facts that would demonstrate one way or the other that this business owner should have anticipated or foreseen that there would be an act of violence and therefore taken some steps to prevent it from happening. So again, courts will want to know, what did the business owner know and when? What do they know about this specific risk? And ultimately, what did they do, if anything, with respect to that information? So as an example, if there's a disgruntled employee in the workforce and that employee habitually makes statements about causing physical harm to another employee, and that employee makes a complaint to management, management or the business owner themselves are going to be found to have had a reason for concern. They're going to be on notice, so to speak, and they will maybe, depending on the court, be found to knew or should have known of that risk and be expected to take steps to mitigate that risk to their other employees. So again, generally a business owner will owe a duty to business invitees, and a business invitee is just a fancy way of saying a customer, and to their employees. In the event that an employee or a customer is hurt in an act of violence, there are a number of theories of negligence that the injured party may file against the business owner. While these claims might not be successful if they're not supported by evidence, they are representative of the types of allegations that could arise, and you should consider these types of claims when you are thinking about developing your policies. What types of claims could they make against your business, and what can you do to help mitigate those risks? One thing I wanted to mention is that liability for the tort or crime of one of your employees as a business owner is relatively rare and difficult to prove. That said, there may be instances when a business could be liable for its employee's crime if the crime somehow fits within the course and scope of their employment. The classic example of this is going to be a bouncer at a nightclub, but it's something that you'll want to take into consideration as retail establishments if you do employ loss prevention or security personnel who are authorized to use force on behalf of the business. Another legal claim or issue that can arise out of workplace violence incidents is a citation by OSHA. These citations are something you should be aware of. They can come with heavy legal fines, and they can also have what's known as injunctive relief, meaning they're going to require the employer to take certain steps in order to rectify a problem that's identified by the administration. So we won't get into the specifics of different citations that OSHA has issued, but it is something that can arise out of a workplace violence incident, and you'll want to keep that in your mind as well. In addition to those negligence type claims, this is something that an employer can face. So again, workplace violence is both an ethical and liability concern for business owners. The cost of prevention is much lower than that of reacting to a workplace violence incident. We discussed sort of the legal issues here and claims that can arise out of an incident, but there's also substantial costs and damages that businesses can face in the wake of such events. And these damages and costs are equally or more troubling than the filing of a lawsuit. So remember, the threat of a lawsuit is not the only thing that we are looking to prevent. There's also irreparable harm to your employees and to your business and its operation generally that we want to prevent through constructive planning. And I don't think we have any questions yet, so we will go ahead and keep going with the conversation. But if you have questions as we go along, feel free to type those in.
Good morning, this is Angela Lewis speaking. In a dealership, you want to have a game plan. To minimize your risk of workplace violence, you need to have strategic human resource policies that should be implemented. In these policies, you want statements to be added. It is our policy to promote a safe environment for our employees and the visiting public, and to work with our employees to maintain a work environment that is free from violence, harassment, intimidation, and other disruptive behavior. Violence or threats of violence in all forms is unacceptable behavior, and it will not be tolerated and will be dealt with appropriately. We will have further slides that will have more details on this. Employee reporting procedures. You need to have a clear chain of command or specific person to report, such as supervisors or HR. When employees report directly to these managers, they need to know that every incident will be taken seriously and investigated. With complaint procedures, same as reporting procedures, they should be swiftly investigated, especially if the seriousness of workplace violence is the complaint. Having an employee assistance program, or EAP, is a great added benefit to the employees. Once you have this benefit, training needs to be held so it allows the employees to have the comfort of having an outside resource to go to for help. This service is confidential and can help all family members living in the same household. Effective screening process and background checks can eliminate hiring those employees that have incidents in the past or prone to aggressive behavior. And then termination procedures. Termination procedures, you need to have a clear process in place to handle each one consistently. Having another manager or supervisor or HR in the room to witness the termination, speak to the employee when no employees are around, or low traffic times as to not cause embarrassment to the terminated employee. Notify security if you have one on site. Collect all access cards, keys, dealership equipment, anything that they may have that is company issued, and then walk out the former employee out of the building. To create an effective workplace violence policy, there's a lot of key components that you should have. During training, questions that are answered, and it needs to be modified so that everybody understands it. We need to cover various acts of violence, including non-physical acts such as harassment, bullying, and other intimidation. It prohibits employees from bringing, using, or brandishing weapons to the workplace unless prohibited by state law. Set a clear and easy procedures for employees to report threats of violence. Provide an alternative reporting system in the event the perpetrator of the act would be the party to whom the employee would be making the complaint. Set a clear, unambiguous disciplinary procedure for employees who violate this policy. Talk about the EAP, and then prohibit discrimination and retaliation against the workplace violence victims. Create an effective workplace policy. There needs to be regular training so that there is consistency with the message on policy in a dangerous situation. This message and training should be for all levels of the organization.
Again, having a workplace violence policy is really important in and of itself, but making sure that that policy is accessible to the employees, that they know where to go if they do have an issue. That's where that training component is key. And also making sure that those policies are being uniformly implemented. Those are your key things that are going to make a policy not only great on paper, but a really great defense in the event of a workplace violence incident.
And keeping that consistency, you're going to have standard responses for everything, which how to notify other personnel or law enforcement, or the zero tolerance policy. Once something happens, being fit for duty if it is an employee to make sure that everybody else is safe. Or seeking a restraining order. There's a lot of different steps that you have to keep consistent with the policy once it's written. I found to have like a simple deterrent and have, since employees are eyes and ears, a simple deterrent of knowing what is going on in your dealership and with employees is to engage them every day. A simple hello, how is your day going, will give you insight into the employee's personality. As you gain this rapport with your employees, they will be more likely to report incidents, large or small, to you so that you can be proactive versus reactive. Employees are your eyes and ears.
Again, training them about building that relationship, building those lines of communication up the chain so that when there is an incident that we as management are hearing about that incident. If an employee feels threatened or has something happen that they would report as a violation, but they don't know, one, that there's a policy, they don't know who to report it to, and three, they don't have the relationship of trust to understand what will happen when they make that report. you're really losing a lot of the benefit of having the policy. So having those things work together in concert is really going to give you the best benefit of having those employment policies in place.
And having the complaint procedures in place too, knowing that they're going to be heard, feeling that their opinions matter, helps resolve a lot of these issues in the workplace. I would also consider providing an EAP plan. It's a great plan to help with personal problems that can impact their well-being at work. It is a great resource for your employees. I have referred many of my employees to use this benefit due to questions that they bring me on finance or their mental health, childcare, alcohol and drug abuse. I've had many instances over the years where these have come up. I have initiated a call to help employees when I knew that there was a situation at home that was overwhelming and they needed to talk to someone about it because it was affecting their work and long-term would have affected their job status at the firm. Although I referred the employee and called in to initiate the counseling to the EAP so they can determine what the employee need was, after the initial call, I was notified that they attended the meeting but was not told anything that was discussed or treated. Ultimately, the employee improved and their performance and was able to stay. I have found that the EAP is a great added benefit. Number one step in hiring employees that will mitigate a lot of these long-term problems that you could potentially have is pre-screening. To identify in the early stages, it will save you money and help with poor hiring decisions. Calling references and previous employees are key to finding out more than dates worked. Questions like, would you rehire this applicant again? You are looking for any discrepancy in work history. People make up fake resumes, fake references, so do your checking.
Yeah, and just to sort of reiterate, so for instance, we're located in Missouri, and in Missouri, employers are restricted from the information that they can disclose to a party that contacts them for an employment reference. The way that we can get around that, and the way that you need to approach this, based upon your state law, is to get an authorization from the employee to talk to someone specifically at their former employer. So once you have that authorization allowing them to talk, you can get more substance other than the dates that they were hired, their salary range, or their title. Those are the traditional things that are made available to future employers. But if a potential employee is not willing to give you a release or authorization to speak to a former employee, that in and of itself can be a red flag that there might be something amiss, and you'll want to do some additional digging, whether it be that employer or otherwise, to try to get a grasp of who this applicant is and what kind of risk they may be presenting to the other people in your workforce. The other thing I would mention is that the use of background checks is something that's really beneficial, but you need to be aware that this is not something that's permitted in all states. Some states are specifically restricted from using background checks. And even in states that are allowed to use background checks, you need to make sure that you do the process properly. If you don't, you're asking for trouble. Generally speaking, you're not going to be able to run a background check until after an employee is given a conditional offer of employment. So keep those things in mind and don't hesitate to reach out to your legal counsel. It is not worth trying to wing it. These things are a hotbed for litigation. The use of background checks in this pre-screening process in general, you can't afford to get it wrong. You need to get it right, not only for workplace violence, but for other instances and issues in the workplace.
You also need to be aware not all states allow employers to use criminal convictions in making hiring decisions. Some states restrict an employer from investigating and using criminal convictions at all in their hiring decisions. Speak with the applicant employment reference to confirm the information provided by the applicant and document the information received. An employer that fails to check employment references can be liable for neglect hiring if a reference check may have revealed an applicant has the propensity for violence. So ultimately, that rests on your shoulder in terms of doing your due diligence before an employee walks in the door.
Yeah, that harkens back to that knew or should have known standard that we talked about. So if an applicant gives you a list of references to call, and one of those references has information about a propensity for violence or some sort of red flag in their history, that if you had called them and talked to them, they would have told you about and you would have been able to document, and you don't take that step, then that can be on you. So again, it harkens back to that foreseeability factor. So if you're calling those references, make sure you're doing a good job of documenting the types of questions that you're asking them and the type of information that they're giving you, because it's going to be it's really your responsibility to make sure that that's thoroughly done.
In cases of termination, once things have escalated, or things can escalate in terms of turning into violence and anger once the employee realized that that is his next step and they were going out the door, you have to be prepared. You have all the documentation in place. You've had all the necessary internal conversations that you need to have. You maybe have checked with legal on this one because maybe it's a different type of case than you've dealt with before, but check with legal on that. You need to be honest and clear when you're speaking with the soon-to-be former employee. Having someone else in the room as a witness also may be deterrent in terms of escalating the situation. Remember, preparation is prevention. I've had employees in my termination meetings throw things at me, get in my face, screamed, crying, threats of lawsuits. If you are well documented and have followed your policies, you should be confident in your termination decision. In these circumstances, less is more when you have the termination discussion.
Yeah, absolutely. We're going to be forthright. We're going to be honest about the reasons for termination. The last thing you want from an employment perspective is to give them ammunition so that it looks like you aren't telling the truth about why they're being terminated. All of the like Angela said, all of the documentation leading up to a termination needs to be consistent and clear as to what the issues were with that employee. Because if it looks like you're wavering, if it looks like you're maybe making an excuse and maybe covering something else up that is the actual reason for termination, that can lead to other problems down the road.
Oh, we were there. I think we're too. It's about
do we have any questions at this point? Doesn't look like we've had any questions come in, so we'll go ahead and keep moving. Again, if you've got questions, don't hesitate to go ahead and get those into us through the Q&A function. All right, so weapons in the workplace. This is obviously a hot topic. You know, we hear the term gun violence thrown around in the media all the time. It's not necessarily indicative, again, of the real state of events or you know, what's really going on in workplaces across the country. But nevertheless, one approach that business owners use to help mitigate workplace violence is to prohibit customers and employees from bringing weapons onto the property. When you're considering this type of policy, you want to make sure that you are complying with state laws and ensuring that there are no specific restrictions or special requirements that you need to have in order to implement those policies. All right, so there are no federal laws that regulate weapons in the workplace. Now, we talked about the OSHA general duty provisions. Those are, you know, that's a general rule that applies, but it doesn't have any specific regulations related to weapons. Now, some states set specific parameters for employers which are designed to protect the Second Amendment rights of employees. These types of laws generally provide a way for employees to store their firearms in their own personal vehicles and penalize employers for restricting activity that would inhibit their Second Amendment rights. Okay, so here's a list of states that have passed statutory protections for employees who wish to carry firearms either to or in the workplace. We won't get into the specifics of each of these laws. However, if you're in one of these states, you need to be consulting with your legal counsel to ensure that any weapons restrictions policies you implement are compliant with those statutory requirements. So again, you might be doing more harm than good if you implement a policy that, even though it's designed to prevent workplace violence, isn't compliant with that applicable state statute. So a common requirement for employers who wish to ban weapons from their business property is a posting requirement. For example, in Kansas, an employer who bans guns must post a conspicuous notice of the ban so that employees and customers are aware of the prohibition. Likewise, in Tennessee, an employer must ensure that restrictions are posted at all entrances to the building where the restriction is to be in place. In some states, such as Alaska, employers may not limit weapons entirely from the premises. Instead, they're only permitted to be restricted and secured or or restricted access areas. While some states may be different, in Alaska, employers are permitted to treat company-owned vehicles as restricted areas of the business where access is limited to employees, such as a product storeroom or an employee break room. The public areas of the business, at least in the state of Alaska, are treated differently, and the employers are actually not allowed to prohibit weapons in those areas. So it's sort of an interesting statutory scheme up in Alaska. You want to look for those, if you are in one of the states that we touched on in the last slide, you want to make sure that you're complying with those regulations. So several states prohibit an employer from prohibiting firearms which are stored safely in a personal vehicle. That said, even when a weapon is stored in a personal vehicle, most states allow the employer to implement prohibitions on weapons when the law requires it. So, for instance, in certain highly regulated industries, there may be a federal or state law which specifically prohibits firearms on or near the premises. So, the example that comes to mind, like a federal courthouse or a state courthouse, can specifically prohibit employees in those situations from bringing a weapon to the workplace. In these types of situations, it would not violate the statute to prohibit firearms. Another type of prohibition would be a law that prohibits convicted felons from possessing a firearm. So look to your state law to see if there's any bans on felons having firearms. And if you are employing felons or former felons in your workplace, be aware of those restrictions. The second area where states generally agree that employer can restrict firearms are on vehicles or in vehicles that are either owned or leased by the employer. So we're not talking about a personal vehicle. This is a fleet vehicle of the employer. And in those situations, most of the states are saying that it's okay for you to prohibit the employee from having a weapon in that vehicle. The next area that is generally agreed to by states that is okay for employers to prohibit the possession of weapons by employees is in restricted parking areas. So you think of certain industries have very specific or restricted ingress and egress to their facility, whether it's because of trade secrets or just the nature of the industry itself, if it's a chemical company, things of that nature. And so in those situations, because the parking situation is restricted, it's okay for the employers to prohibit the possession of weapons. So finally, some states allow employers to prohibit weapon possession in restricted areas, but only if they provide an alternative means of storage for the employee. So, if they provide an alternative parking arrangement, or if they provide some kind of situation where the employee can bring the weapon into the workplace and check it with a specific designated person or room at the employer. So be looking when you're looking at your state scheme for situations like that, so that when you're drafting your policies for your dealership, you can make sure you're complying with those requirements. So we talked about statutes protecting an employee's Second Amendment right to possess a firearm, but there's also some state statutes aimed at protecting employers from liability related to gun violence. For example, in Idaho, an employer is not liable for civil damages for allowing or prohibiting firearms in a personal vehicle on the employer's property. So this would protect an employer in a situation where, for instance, the employee was assaulted and then later claimed that the employer's prohibition on firearms either caused or contributed to their damages. So they're, assaulted either getting into their vehicle or exiting their vehicle. In that situation, Idaho has specifically passed law to make sure that employers are not going to be liable for having a policy that is compliant with Idaho law with respect to firearms. Similarly, under Texas law, employers are not liable for any type of personal injury, death, or property damage, so long as they follow the statutory requirements for allowing guns in the workplace, and they are not grossly negligent. Grossly negligent is a really high standard to meet legally, and so this is a pretty significant protection for employers that allow employees to carry in the workplace. In addition, some states have gone so far as to protect employers who allow weapons in the workplace to be carried by employees. So this is a totally opposite end of the spectrum. This is employers who are saying, okay, well, employee, you want to carry a weapon in the workplace, these are the rules. And, you know, some states have gone so far as to protect the employer who chooses to do that. You know, these statutes, I think, are a reaction to OSHA action taken against employers under the General Duty Clause, with OSHA claiming that the employers violated their general duty to employees by allowing firearms. This is the state pushing back against that federal force and saying, you know, federal agency, you've overstepped your bounds, and we think as a state that the fact that this employer allowed weapons to be carried by employees in the workforce wasn't in and of itself a dangerous condition. So again, you'll want to look and see if there's any of those sort of statutory protections that you can avail your dealership of when you're developing your policies.
We have no questions as of right now.
I do want to make a quick comment though. We've had a couple of people ask about the availability of this presentation afterwards, and yes, we will make the slides and the recording available to everyone who's here. So just a thought on that. And also, in case we weren't clear earlier, all your questions are private, so we read them here, we can answer them one-on-one, or if we think it's a good question that's applicable to the whole group, we'll answer it out loud at a break. But just want to let you know that those questions, your fellow participants aren't going to see your questions.
All right, next step in the whole process is to create a safety plan, create a safety team that will help assess where your weaknesses lie and what you need to do to keep your employees safe. You need to assess potential threats and then create some policies to protect all of your groups: management, operations, facilities, your legal department, human resources, and even some non-supervisory employees. Surveys. Surveys are a great tool to get feedback. Sometimes you can get those young people or drawing conclusions or bringing things to attention that they don't know if the employer knows about. But ask for feedback whether they feel safe at work, whether they perceive any potential threats of workplace violence, any security measures in place. You want to look for suggestions and improvement of workplace safety. Remember, the key component to liability is often foreseeability, such as the employer must be aware that the survey must be used as evidence that the employer was aware of the potential threats in the workplace if an incident later arises. Documentation must be created to demonstrate that the survey was taken, what steps were taken to the employer to address the issues that were identified throughout the survey process. I would almost approach your survey globally too as almost an audit. We do audits of financial books and audit of other records too, but your location could have a checklist as well in terms of an audit. You know, has violence occurred there before on the premises or while conducting business? The alarm systems, are there panic alarm buttons, silent alarms? Do people know how to work those? Has there been proper training? Is there malfunctioning locks, windows not secure? So there's things that you can walk through and visibly check as well in terms of your security and safety of your employees. And that will help with the next step with training and security in terms of your dealership.
Well, in using that information proactively, so using that information, again, this is allowing the employees to be your eyes and ears as management. Maybe you don't know about a lock on a storeroom that is an issue. Maybe you don't know about something, but you know, taking the opportunity to ask your workforce, how safe do you feel? If you don't feel safe, why? Tell us what those issues are. Help us identify what the issues are. You know, do we need to add more lighting in the parking lot? Do we need to have a different walkout procedure at the end of the day? Let the employees help you identify where those risks are, because chances are they're going to be experiencing those concerns firsthand, whereas you're not. So take advantage of that. And then again, I can't stress enough in all employment-related things, you live and die by your documentation. Your word after you're accused of doing something wrong is going to be worth very little. They want to see what you did to address any concerns that are raised. If they turn out to be not legitimate, you need to, you know, be able to describe and have documentation showing what you did to verify that it wasn't in fact a problem and why no steps were taken to prevent whatever the act was.
And Natalie covered our next slide, and that was a lot of the points raised on this slide, is to make sure that employees are not working in isolated areas, that there's some sort of buddy system created, or they can modify their hours to accommodate so they do feel safe, that they do have the lighting and appropriate responses from emergency personnel or when they reach back to a supervisor or manager. We're moving on to active shooter training. An active shooter is defined as an active shooter who is individually actively engaged in killing or attempting to kill people in a confined or populated area using firearms. Develop, implement a specific plan to address an active shooter scenario. Various plans, and I'm going to go into this in later slides too, action based upon the given employee's location and situation. You want to run, you want to hide, and you want to fight. That is your absolute last resort. You need to teach employees to recognize the warning signs which may signal the presence of an active shooter. Active shooter situations evolve quickly and are unpredictable. Incidents is over typically in 10 to 15 minutes, and sometimes before law enforcement is even on the scene. The Department of Homeland Security has a lot of good practices and advice on how to respond when an active shooter is in your vicinity. First, you want to run. If there's an accessible escape plan, attempt to evacuate the premise. Be sure to have an escape route and plan in mind. Evacuate regardless whether others agree to follow. Leave your belongings behind. Help others escape if possible. Prevent people from going back into the building or an area that you just came out of. Follow instructions of any police officers once they reach the scene, and when you're safe, call 911. If evacuation is not possible, you want to hide. Hide in a place where the active shooter is less likely to find you. Your hiding place should be out of the active shooter's view. Provide protection if shots are fired in your direction, and not trap or restrict you. To prevent an active shooter from entering your hiding place, lock the door, blockade it with some type of heavy furniture. If an active shooter is nearby, silence your cell phone, turn off any source of noise, hide behind large items, but remain quiet. Fight. This is your very, very last resort. If only when your life is in imminent danger, attempt to disrupt or incapacitate the active shooter by acting as aggressively as possible against him or her. Throwing items, yelling, but you have to commit to your action once you go in that direction. And then once law enforcement arrives, there are going to come in teams of 4 typically. They're going to have their uniforms on, they're going to have tactical gear on, they're going to be yelling and screaming, trying to determine who is the shooter and what direction they need to go in. You need to remain calm, put your hands up so they know that you are not the one that is the active shooter, and answer any questions that they can have in terms of location, number of shooters, physical description, and the type of weapons that are held. So being able to present information to help law enforcement once they get there is key too.
And again, so this harkens back to the statistics that we looked at. 85% of workplace violence incidents that result in a homicide are caused by an outside person that doesn't have a connection to your business. And so preparing for these kinds of scenarios, as uncomfortable as it may be to talk about with your employees, is absolutely critical. Those 3 options that they have, under those unfortunate circumstances and what they can do to make themselves safe, covering that ahead of time so that they're not just left to their own devices is absolutely critical.
And that training is key. Training is going to be absolute key to this. And not only if you're not comfortable in talking about this, there are outside vendors or your local law enforcement that will absolutely help you come in and develop a plan and help with training activities as well. And I think that is it. We have any questions?
If we don't have any further questions, like I said, I'd just like to reiterate, members of EDA have the online legal hotline, and we are available to help with questions if you've got a workplace violence policy you'd like us to take a look at, or if you have other questions about this topic. We, of course, are happy to help you with that. Or if you want to speak with Angela some more, I'm sure she'd be happy to as well. Just give us a call here at the association. But if there's no other questions, we'll go ahead and wrap up, and everybody have a great day. Thank you.
Thank you.